just going to let her know that you're here as well, so that we've got somebody, a witness to it. Push Ed. Hey, why is it not coming up with you? Okay, hold on. Vanessa. Yeah, I'm just trying to give her a call. Hold on. I think she's on the phone to someone else. I might have to try ringing Graham and see if she's ringing him. Okay, hold on. Sorry to quickly do that to you.
Hi.
Oh, hello. You're there. Okay, hold on. Are they still there?
Yeah. Hang on. She's just trying to say something. Go ahead.
Okay, under section 1051C, because
Yep.
there was no arrangement in place for a living arrangement, there was an access arrangement, not a living arrangement. OT can arrange for the child to be uplifted on such terms as the delegate, so that's Jono. I haven't written it all down properly. Can be returned. And the agreement was that he was returned at 5:30 yesterday afternoon.
As I've explained to you, there was no agreement.
Okay, so the part of misunderstanding is that under 1051C, an agreement has to be made for the placement of a child. That's how they place a child into a permanent care arrangement. Okay, so when they seek a caregiver, that's what the caregiver one is based on, 1051B and C, and sometimes under 364.
Oranga Tamariki can place him wherever and whoever they want to place him with, because they have a 101 custody order. Yep.
No, that is incorrect. That is incorrect. We have had this argument with OT last year in the High Court. Okay, I spoke.
Yeah, we don't need to talk.
I can't understand what this guy's saying. He keeps talking and talking. We need to tell you, Vanessa, that there is, and he can listen. I'm fine with that. He can just, yeah, I'm happy for him to listen. There is a 101 custody order, and Oranga Tamariki have custody of Adrian. They said yesterday to you that you are to bring him back after that meeting. You're to bring him back at 5:30, and you didn't do that. Hence, we are here. We do not need a warrant to be here. Under the Oranga Tamariki Act, we do not need a warrant to be here, because right at this moment, Adrian needs to be in OT care, not here.
That would be appropriate if Oranga Tamariki had not allowed the child to be subject to risk.
Here, Adrian is coming with us. We're going to do this right. We've done it right. We know we're right. Okay.
Well, you may feel that way, but I'm going to inform you of something right now. This interaction is being captured. It is also being live streamed. What you are doing is completely against the Oranga Tamariki Act. I have proven this myself in the High Court with Crown Counsel last year, and had my granddaughter returned to our care pursuant to 104 and 105 being incorrect in the way you are applying it right now. Our granddaughter was returned to us a year ago on the same basis. You have a misunderstanding of your own act. Well, if you don't understand what I'm talking about, then there is big issues. You should not be in social work. You need to.
No, these are the police. These are the police, not the social workers, Brent.
Well, okay, I'm going to tell you now, officer, that what the social worker or whoever that person was is informing you of is incorrect. And like I said before, they are incorrect. We proved this through the High Court forum. We had settlement out of court because Oranga Tamariki was in the wrong. Oranga Tamariki have allowed this child, a 13-year-old, to be put at risk in a placement they placed the child with. Very similar to what happened in our case. Now, when it comes down to it, 104 and 105 do not apply in the way that the social worker is telling you it applies. I've gone through the law on this, and I've had to present in court to this and to Crown Law. So I have a better understanding of their act than they do. What you are about to do is traumatize a child that does not need to be traumatized. You are traumatizing the mother as well for no good reason at all. This Oranga Tamariki were aware of the fact that this pedophile, convicted pedophile on Home D was at where this child's placement was. They have told the court they were not. We are well aware that they have been aware for at least a month. They have placed this child at risk, serious risk. There has been a memo put into the High Court to be able to allow the judge that heard this appeal to understand what John O'Cotton, the social worker, has been putting forward to the court is misinformation. They have not supplied the correct information to the court. I am well aware of the case because I have been helping with all of the paperwork behind the scenes for the last year and a half. So I know exactly where this case is at and where it should be. And that boy should be returned home to his mother. There should be no order in place at the moment. I understand that there is a current 101, but that is because the court has been misled and these orders should have been discharged many months ago. But they cannot get discharged when social workers and the OT Council keep lying to the family court. And at the moment, they are misleading you as officers. And like I said before, if you want to pursue your action and uplift the child, I will help them both, help her and her advocate file for a tort of professional negligence against New Zealand Police. And that will include the two officers that are, as far as I'm aware of, there's two officers there at the moment. That will include the two officers that have attended today personally. So there will be a case against New Zealand Police and the two officers that are at that doorstep. So I would suggest, like I did before, I'm asking you to go away and ask them to apply for the warrant that they require. The 104 and 105 do not give the ability to enter the household or in any respect. Under 105.1d, they don't have an agreement to cancel. That's the issue. She's trying to say that there was an agreement. Okay, if she's trying to say that there's an agreement in place, ask her to provide you with the 128 plan that has the agreement. And if she can't provide you with that, then ask her to go back under section 135 urgently on a without notice ex parte application and ask the judge to review the plan of where this child is going to that the court doesn't know about and can't approve yet. They are trying to place this child into another household that the court doesn't know about. They must go and get the permission of the court to do so. Look up sections 135 and 134 of their act. 131EA says that they must do this as well. They have to have an adequate and appropriate plan. They have not filed one with the court, and until such time as that is done, that child should not be going anywhere at all. Because the court needs to see what is appropriate, not the social worker. This is what happens daily. I deal with this daily with supporting many people, and they are always misleading the court, just as they did in our case. Like I said, I understand you're there to do a job, but the job you're there to do is not to traumatize that child or that mother. So, like I said, what I would suggest to you is go away, talk to OT, get them to get the appropriate paperwork done, which is what they should have done instead of calling New Zealand Police to come out. They've done this to New Zealand Police for many, many, many years. You're used as a scapegoat because theoretically, if 104 and 105 could be executed, it could be done by them. Why are they not there themselves, just doing it themselves? Because they know they don't have the ability. They have not made a plan for that child to be placed there. Therefore, under 104 and 105, especially 105, 1B and C, which is in regards to the placement, they haven't made an agreement with the mother at all. There is no written agreement within a 128 plan. So on that basis, 105, 1D does not apply. There is nothing to cancel, and you are supposed to leave the property. So I would suggest you think very seriously about going forward on this, because there will be repercussions from it.
Thank you, we will.
Thank you. And I would also suggest to you that if you're going to do anything, it would be to leave the property, go away and do it, and don't keep subjecting the mother and the child to trauma while you keep standing outside and they're terrified because of it. That is not the way to deal with the situation. The proper way to deal with it is to go away, get things sorted out properly through the court, which I doubt OT will want to do, because it then means that they've got to tell the court the truth as to what has happened. They're using you guys as a scapegoat to not have to tell the court what they've done. So I would respectfully request of you to go away and sort it out rather than stand on their doorstep and traumatise them further. She's not going to go anywhere. We were talking about that last night. She was terrified. I told her she needs to stay there and deal with it there. She's not going to go anywhere, but go away and sort this out properly and make OT do their job properly instead of traumatising children through uplifts. Because this uplift is illegal. Exactly. But like I said, this is being recorded and live streamed because I want to have this sort of stuff out there, because too many times does OT get away with traumatizing children and their families, and you guys are doing the work that they're asking you to do, not realizing that what they're actually telling you is not correct. So I would hope you would take that on board and not traumatize this child further that's wanting to get away from them. He wants to be with his mother. So could you give us some sort of clarity as to what you plan on doing moving forward, so this mother and her child don't have to stand there freaking out all the time and being traumatized?
Senior personnel from police to decide what to do, okay?
Sorry, what was that?
We are speaking with senior personnel from police to decide.
That would be great if you could do that. It's just that we don't want them traumatized any further.
No, and I appreciate Mum to come outside and speak to us so that we weren't yelling through the doorway and the child was inside listening. But Mum,
I understand that, but you have to understand from a parent's point of view and a grandparent's point of view that's been through this before. The minute the door is open, a foot is put in it and force is used. So I can honestly say, from my point of view of having an uplift happen before, that I understand what she's going through.
okay, well,
It's you're talking to someone who's got first-hand knowledge with uplifts. We've been through them, and a lot of these uplifts are unlawful, including the one today that you are about to try and do. So that's why I've asked you to go away, consider it, ask them to go and get a warrant. If they believe that they have the grounds to do what they're doing, go and get a warrant for it.
I'm not sure if they're still at the door or not.
Okay, well, hopefully they're not. Yes, that was what I was trying to be able to get done. There's no need for reassuring.
I think they've gone out to the 2OT at the road.
Okay.
Because I told OT, I told them that I trespassed John O'Cotton.
Yeah. Well, yeah. Sorry, I didn't let you know there, Vanessa. But I got Mark on the line because he's able to capture these kind of things. So if they had tried to do anything, we at least had evidence for the court.
Yeah. Because they're just trying to bullshit.
Oh yeah, I fully understand. Yeah. Yeah. But as soon as I hung up from you, I rang Mark and asked him could he set up to capture this, because I wanted to get him on here because he has the gear to capture the video.
Yeah.
So yeah, I just thought, if something does go untowards, we can at least produce it to the court.
Yeah,
So yeah,
because
Mark,
I think OT are obviously pushing them.
oh
They're
yeah, of
coming
course.
back now.
Okay,
They've now got a third policeman here as well.
okay, just do it.
Because I can see a man wandering around out there in a police uniform.
Okay,
And he's coming to the door now.
okay.
Or I thought he was. Oh,
Just
yeah.
be careful. Okay, so-
Yeah.
Let's go, mate. It's Mike here from the police.
Hi, Mike.
Hey, we'll come to uplift the young fellow. What's the issues going on?
Brett, do you want to tell Mike why we're not letting him go?
I don't want to talk to them. I want to talk to you, mate.
Because your uplift is illegal.
No, it's legal.
It's not legal.
We don't want to arrest you for
You need to get a court order to uplift my son.
No, we don't. We don't really want to arrest you, mate. So if you continue to obstruct us, that's what will happen.
Did you hear that? They're threatening to arrest me, Brent.
On what grounds? He's talking about an uplift that he's trying to perform that is illegal. 105, 1B and 1C, there has been no agreement for Adrian to be at your house. Therefore, under 105, 1D, there is no agreement to cancel. 104 does not come into play because of that. I have already been through all of this last year with Crown Law. Just because you're a police officer does not give you the right to abuse your powers. 104 and 105 of the Act do not allow for what you are trying to do. You're being misled by Aoranga Tamariki. This has been happening for many years. I've had the same thing happen occur with my granddaughter last year. I had communications with Crown Law, and everything was pulled back because of the fact that they were breaking the law. So if you want to go ahead and execute this uplift, your QID is required and your name for a tort of professional negligence, because you are using negligence in your professional capacity to try and execute something that is not executable. I have all of this in paperwork from October, November last year. So as I suggested to the other officers, I would suggest you go back to OT and ask them to apply for the appropriate warrant that they need to apply for, because no agreement was made under 105, 1B and C. There is no ability to uplift that child. You do not have, even though the Act says further down, reasonable force can be used. That is providing there is an agreement to cancel. Again, acknowledged by Crown Law, acknowledged by the High Court of Wellington last year. I have this all in documentation.
And that's annoying because he's just on repeat. I've already heard what he's had to say, and I understand what he's saying, but we need to speak to you, Vanessa. We're not getting anywhere talking to this guy.
Because he is quoting the law to you, and you know that he is right.
Exactly. Then take it on board and go away and ask OT to apply for the appropriate warrant that they're supposed to get. Don't have a go at the mother because she doesn't understand the law. That is why she sought the help of an advocate and myself through the legal process. She has every right to ask for someone else to speak on her behalf. That is what is called a support person. I am supporting her through this because she doesn't have a full understanding of the legislation. I have a full understanding of this exact kind of thing happening because I have been through it.
Adrian doing on there, mate?
He's in his bedroom and he's obviously very upset by what you guys are trying to do.
Well, you obviously know why we're here. We can't leave. So how are we going to work towards a resolution here?
The easy way to work forward on the resolution, like I said to the other officer, is ask OT to apply for the appropriate warrant. Okay, they know they should be doing this. They have turned around and come up with a new placement for this child that requires a 128 plan to be put to the court under a 135 review under their Act. They haven't done any of these things. They are the ones breaking the law. So at the end of the day, you've got a social worker and whoever his outsider is there. Jono Cotton has never been honest with anyone. I have sat in on meetings with this woman and called him out on the stuff he is doing wrong. At the end of the day, all we are asking for you to do is to go away, get them to apply for the appropriate warrants. If the judge gives the warrants, okay, then it's going to have to be executed. But at the moment, there is no agreement under 105(1)(b) and C. They're saying that they had an agreement for him to stay at Vanessa's till 5:30 yesterday. 105(1)(b) and C doesn't cover that. That covers living placement. So as they said, 101 is the custody order, 104 is the effect of the custody order, 105 is the placement of the child and where they will live. It is not a case of in regards to contact. 121 deals with contact, so they need to stop misleading New Zealand police. I see the other officer. I understand you're there to do your job, but your job is not to traumatise this child and this mother, and that is what you're doing. So the simple way forward is to get them to apply appropriately to the courts and put in a 135 review like they're supposed to do, because the material change in circumstances for the child. They are supposed to apply, put another 128 plan into the court, get the judge to approve it under 135 of their act, and if the judge approves it, the judge will then issue the warrant to come and pick the child up. They won't do that because they know that they've caused the circumstances, and Jono knows that he was aware that this convicted pedophile was at the caregiver's house. So all we're asking you to do on behalf of the mother is to go away and get OT to do their job correctly, instead of trying to involve New Zealand police when they haven't actually informed the court yet that they're going to move this child. They've only just reviewed the plan 2 months ago, and now they don't want to review it because they know that the court will ask questions as to how did this come about. I've received a copy of a memorandum from the High Court Counsel from OT today, and it clearly states in there, they've tried to state in there, that the social worker didn't know this person was at the caregiver's address. That's lies. He's known for a month. So if he can lie to their own counsel in Crown Law, what do you think he's going to be doing to you guys? He's trying to mislead you, and all I'm asking you to do is not put this mother and son through trauma. Ask for them to go and make the appropriate applications. If it's done in the correct manner and the judge says that the uplift's got to happen, then that's what's got to happen. But at the moment, there is no reason and no grounds for what you are doing. So just be aware of the fact that on that basis, you're also liable as a police officer.
Yeah. So
For what? Your professional negligence. You're trying to execute something that is not executable.
And you're live on Facebook.
And, you know, as I said to the other officers, okay, I asked the mate to come on board and capture this, so this is all being recorded. It's also being live streamed, because too many times are children being uplifted and traumatized because of what OT tell you. So what I'm saying to you is, okay, I support about 14 families going through the court, including Miss Hayward here, Miss Vanessa here. But the thing is, you don't need to be doing what you're doing. All you need to do is go away and get them to do the appropriate paperwork that they know they have to do, instead of misleading you. And then if the court comes back and says, yes, this child needs to go back, then that's what needs to happen. But there is no agreement under 105(1)(b) and C. Therefore, there is no agreement to cancel under 105(1)(d). Your officer said an agreement was made for him to be here till 5:30. Sorry, but 105(1)(d) deals with living arrangements, not contact. That is two specifically different things. If you want to go away and look up the Act, 121 deals with contact. And if anything, the other thing to understand is this. Okay, Section 8 of their Act is decision making. Aoranga Tamariki, in most cases, including this one, are an additional guardian under Section 110. Okay, so they're an additional guardian. They don't get to make the main decisions. They keep telling everybody that, okay, we have to make the main decision on where he lives. That is not the case. 105 says, yes, the chief executive will make the decision, but that is subject to the guardian, Vanessa, saying, yes, he can go there. It is not automatic as they make out to everyone. Again, another point I have proven in the court forums. So like I said, all I'm asking you to do is please don't traumatize this child. He's been through enough. I've been supporting this family for 13 months, and I know the whole case. So what you're doing is in my view, completely unlawful. And you do not have the grounds to be there at the moment. And if you use force to try and enter that dwelling, okay, that's breaking and entering. And when it comes down to it, under a tort of negligence, you are liable as an officer for that. Exactly. And like I said to the other officer, it won't be just New Zealand Police that I will help to file against. It will be New Zealand Police and the officers that have attended. Because you can't keep thinking that it's okay to keep traumatizing families. You don't have to live with what they go through at the end of the day. This mother is traumatized. I've been watching her on the screen. She's traumatized. I know the boy doesn't want to go back either, and that's his right. Nobody's listening to his view under Section 6. You know, when it comes down to it, he has a view in this. If he wants to stay there, he doesn't have to go back. He's 13. One more year, and New Zealand Police would be telling a parent, well, he's 14. You can't tell him what to do. The same applies with Oranga Tamariki. But like I said, please consider what you're doing, because he does not need to be traumatized further. This boy has been running away from the OT home and OT because he does not want to be there. He's scared. Just remember this, okay? You're a police officer. You have the discretion to make decisions, but please don't make your decision please don't let your decision become one that's going to hold yourself accountable personally. You know, if it comes down to it and they get a warrant, they get a warrant. But at the moment, that boy needs to be at home. That's where he wants to be.
Sorry, what was that?
What's that?
Social workers outside. So a couple of colleagues are chatting to them to try and figure out what the best plan is and how we go about it. Okay? So they are working on it.
So you guys are just going to hang around till they decide?
Is the officer still there, Vanessa?
Yeah, he's still at the door.
Okay, can he hear me still?
Can you still hear him, Mike?
Okay, Mike, can I put this suggestion to you? At the moment, there is no agreement under 1051B and C for the child to be there. Okay, there is no agreement. Could you put this suggestion forward to them that could solve the problem quite easily? 1051B and 1051C mainly. Okay, but 1051B and C. Make an agreement with Vanessa to place her child with her in the interim. Okay, until such time as the matter can be heard by the court. He's there anyway. He's there 5 days a week and stays there two nights a week. This is better than putting him through the trauma that you're doing right now. Okay, and it's an easy solution. And this is something that has been put to John O'Cotton, the social worker, many a time. But due to plain ignorance, he just doesn't want to see that happening. This boy wants to be with his mother.
Yes, he stays here 2 nights and he's here 5 days a week.
So there should be no issue in having him stay with his mother under 1051B and C until such time as the court can have a plan put before it with that in it. It's really what it is Mr. Cotton does not want this child to return home, and there is no reason for him not to return home. The child is not at risk. I mean, if the child was at risk, they're certainly not going to let the child visit 5 days a week and stay 2 nights a week. I mean, common sense tells us that.
1051B and C, isn't it?
Yes, 1051B and C, that's the placement of the child, okay? So the delegate can say, yes, he can stay here, okay? And that will have you off the doorstep, okay? All they need to do is draw up a new 128 plan stating what they've told you they're going to do in it, put it to the court, and put it into the court with an urgent application under Section 135, attach the plan to it, and the judge will approve it. It's over and done with.
Hang on, there's a tractor going past. You'll have to wait a minute and tell him again.
Okay.
Can you hear now, Mike?
Still there, sorry.
Yes, but let's just see if we can negotiate just to get it done.
Oh, the name. Okay, I'll get him. I'll get him to come around the deck. Hang on.
Okay.
Hey, Mike, do you want to come around the deck and you can talk to him there?
What was that?
If you walk round my deck, then you should be able to hear him.
I'll just...
Sorry, the neighbours decided to mow right next to the back door.
Oh, that's okay. I'm just going to quickly go into...
Alright, sounds like it's gone.
Okay, he can hear you now.
Okay, so my suggestion, Mike, is, okay, under 105(1)(b) and C, okay, because the two subsections really do go together, even though Oranga Tamariki will tell you, no, they don't. 105(1)(b) and C, especially 1C, okay, the Chief Executive, acting through the Chief Executive Delegate, which is Jono, may arrange for the child or young person to live temporarily with the parents or guardians, in other words, Vanessa, or other person previously having care of the child or young person, or with any other person such as the delegate decides. Now, this child is seeing his mother 5 days a week and staying overnight 2 days a week. So there is really no reason why that can't be implemented into the 128 plan for the child to live there, because he's pretty much living there anyway. So my suggestion to you would be to put that to Mr. Cotton and state to him that it is not unreasonable, considering the fact that, okay, besides 5 nights a week, the child's living with his mother anyway.
Please, I've got something to show you here now.
I'm not opening the door. You can push it under the door.
No, it's on my phone, so I'm not doing that.
Well, you can tell me what it is.
Okay, so what I have here is a custody order. It was signed by Judge Deputy Magistrate Jensen on the 17th of March, 20th of March, sorry, it was signed. On it, it states that, yes, and it's valid now, and it states that Adrian A. Howard, under application made to the Crown Court, makes the following order. The Chief Executive of Oranga Tamariki Ministry for Children shall have custody of the above named child or young person. This order remains in full force until the child or young person to whom it relates attains the age of 18 years or sooner if the young person marries, or the children or young person to whom it relates is adopted by any other person other than his or her parent, or it is buried or discharged by the court. So, Vanessa, I'm just telling you now that this order shall be sufficient authority for any member of the police or chief executive acting through his or her delegate or any other person authorised in on behalf of the chief executive to exercise the powers conferred by sections 104.2 and 104.3 of the Oranga Tamariki Act 1989. In exercising such powers, any member of police or the chief executive acting through his or her delegate or any other person authorised in that on behalf of the chief executive may, for the purpose of removing any child or young person, enter and search any dwelling house, building, aircraft, ship, carriage, vehicle, premises or place with or without assistance and by force if necessary, and may use such force as reasonable to place the child or young person in a residence as directed by the chief executive. Along with that, a warrant is not required for the purposes of executing these powers. So now, Vanessa, what I'm telling you is that we are going to take Adrian tonight. We have the authority. We've done our research. And
Well, you need to research a bit further, because the Section 101 custody order is subject to Section 104 and subject to Section 105.
Windows at your premise, then Vanessa. We would like to take Adrian. Come to the door, and police are happy to take him. I know you don't want OT to take him. We're happy to take him. We'll make sure he's in very good care.
Oh, come on. You haven't done that already. That's why you're having to remove him. And that's why you're wanting to remove him. Your Section 101 order, and what you're not telling the police on the doorstep there is, it's subject to Section 104, which is subject to 105. Okay? Like I said, had this legal argument in the High Court. You're obviously a person with great ignorance who thinks that they know everything. Unfortunately, you don't. Now, what I've said to the police officer is correct. How about you stop trying to...
They're threatening to arrest me, Brent. The police are threatening to arrest me.
Okay, how about
Well then, okay, if you do what you need to do, Vanessa, but they are breaking the law.
okay?
We can do that. We've checked it out. We've listened to you. We've checked it out, and that's our right. We have the right to do that.
We don't
Is
want
that New Zealand police talking to you or the social worker?
The police.
rather you
Well, New Zealand police are really wrong again.
Please, this must be upsetting for Adrian, and we just want him to get him into somewhere that's safe tonight. I know.
He's safe here. That's why he's here, because he's safe.
I know, but he's got to be under somebody he cares. He just has
He is under Oranga Tamariki care.
Here he's not, Vanessa, he's not.
He is.
There is the ability for him to be under Tamariki care pursuant to 105, 1B and C, but you are not allowing that. All that has to happen is a placement for him under that. They haven't got a plan before the court. They don't have a review before the court yet. You're breaking the law, officer.
We'll take him away. And then
Why don't you just speak to Mike about what was discussed with Mike? The other officer out there. So are you telling me that that officer is not Mike and he lied to me about his name? Right, we'll go and talk to Mike. Because we've just spoken to Mike. Go and talk to him. Show me the warrant then.
What's happening?
They're telling me they've got a warrant on their phone.
Well, then tell them to email you the warrant.
it's part of the custody order.
They're claiming it's part of the custody order.
No, it's not. No, it's not.
Custody order, and I'm not going to argue with you.
Well, nobody's asking you to argue with anyone. We're telling you that when you look at the Act, you are reading the Act wrong. I have been through this personally myself with my granddaughter's case, like I said, and you are wrong. It has been proven that you are wrong. You are about to break the law if you break into that house.
There's a machine out here, and I can't hear what you're saying. Vanessa, can you open the door, please? We need to come and see Adrian.
No, do not open the door.
Vanessa, please. We don't need this guy. We don't need this guy in the...
We do, because you are bullying me.
You've already...
We can't hear anything. I can't hear what's going on.
With force of necessary.
They're going to break the door down, Brent.
I don't want to break the door down. That's why I'm asking. Can we open it, please, and just walk in like adults?
Why? So you can then take the child.
I don't want to break the door down. I'd much rather that you open the door and we just discuss this like adults and
Well,
You're not going to discuss it. You've just told me you're going to rip my son away and terrorise him.
no, I did not.
Vanessa, do you have a window by your door?
Yeah, I do.
Okay, if you've got a small window, just open the window a little bit.
What? There went half the stuff on the window, but never mind. No.
I don't know what that was. What was that?
Hang on. I've just got to take everything down before I break the rest of it. That's if we can get the window open. No, we can't. I'd have to open the side window. Hang on.
Okay. I don't know what's going on with your internet, but it's very blurry there, Vanessa.
Yeah, I've got the window open.
Can you hear each other better now?
Can you hear him?
I want to hear you, not him. I've got this order here from my... It's the custody fact that can you look by force if necessary to uplift Adrian. I don't want to enter by force. Okay, I just would like us to sort this out now. Adrian,
Then you've been told what to do. Mike knows what can be done.
I've got a custody order here that says that this is what we have to do. And
The custody order does not give you the right to enter my
it
house.
does. It absolutely does. Vanessa, it absolutely does.
She's just
No, it
going to
does
argue
not.
the point that the custody order gives them the right to enter.
So was that a cop or was that the was it
No,
social
this
worker?
is the cop.
Vanessa, it absolutely does give me the right to enter with force by necessary.
Can you hear us?
Yes, I can. Okay. Once again, okay, I've been through this with Crown Law and the High Court. It does not give you the ability to do what you are stating. Okay, 101 is a custody order. 104 is subject to 105, 1B and C. The child must be placed in a placement, and then that placement
Well, you
must
are
be.
going to be using force because he ain't going to go with you voluntarily, I can tell you now.
Okay, that's fine. Then we
So you are going to traumatise my kid.
I'd much rather you speak to him and just say, look, we have to go with these people.
No, I'm not going to lie to him. He knows he doesn't have to go.
But
He knows he's safe here. He knows
He's
he's
13. He does not need to go at all. But the thing is, okay, there is no agreement under 105, 1B or C that he's placed with Vanessa at the moment. So there is no agreement to cancel under 105, 1D. You can read the interpretation however you want, officer. Okay? The problem is your interpretation of the law is incorrect.
we have to.
Well, you guys better all write down your names and your IDs because, like you've been informed, they will be taking this for a tort.
Okay, that's fine. We're acting on behalf of a judge, okay? On behalf of
No, you're not. No, you're not. A 101 custody order does not give you the ability to act on behalf of a judge. Don't try and act like that 101 custody order is a warrant. It is
You're
not.
breaking the door down, Brent.
It's up to you what you're going to do. We've if you don't want to have it damage to the property, then you're going to have to think. But like if need be, we'll have to sort out filing in the next few days on a tort against them.
Okay. So I should unlock the door now?
Like I said, that decision's yours. I mean, when it comes to that, I mean, he's your child. You're trying to keep him safe. They don't have the authority to do what they're doing. We've proven that. They're misleading. They're misreading the law and misinterpreting it. They do not have the ability to do it.
Yeah.
So, yeah.
Yeah, well, he's already screaming in the bedroom.
Yeah, so he's already traumatized. He doesn't want to go.
Yes, love. Pardon? They've been trying traumatizing him through his bedroom window, he told me.
Oh my God, really? That's
Come
disgusting.
here, baby. Come here, honey. Come here. Come here, baby.
Oh, honestly, the unfortunate thing is I can believe they stoop this low because they do. I mean, look at that. Does that look like a child that wants to leave his mother? No. You would think New Zealand police would come to their senses and get them to go away and make the appropriate applications. Power gone to the head like usual. Exactly. Yeah.
I'm aware that they're outside the window. I'm not you. It's okay.
Exactly. Exactly.
I love you. You know where I am and you know how to get hold of me. You remember that, okay? You know where your safe places are. His caregiver has his stuff, not me.
We'll just stay on here until such time as all, if it does happen.
The police are coming in now. I can hear them coming in.
Hello, guys. How are you? You okay?
How do you think we are? You've traumatized me and you've traumatized my son.
Didn't really go like this, though.
No, it didn't. You should have left. They don't have the orders. The Section 128 plan is not valid without the judge signing it. You know it.
Judge has signed it, mate.
No, that plan doesn't exist because it says he's to live with Liz Fenn. So that plan is no longer valid. That order is no longer valid.
Hey, we've already resolved it. We're not going to stay here all night. Okay, Vanessa? And we don't want to arrest you, mate. It's the last thing I want to do.
We're on live Facebook.
Who is the officer that's there, Vanessa?
Who are you?
Hey,
Mike Fagan, the one
Ah,
you were talking to.
The one we spoke to before. So I'm gathering that even though we spoke to you about these sections, Mike, you're choosing to ignore them.
he's not helping us, mate.
He's saying you're not helping, Brent.
Oh, of course I'm not helping because I'm the one who knows the law behind it. At the end of the day, whether you like it or not, if this goes ahead, you're going to be held accountable. You do not have the authority to do what you are doing. It's written within the legislation. And like I said, we proved this last year. New Zealand police cannot keep going around abusing their powers.
Have you written your names down and your QID numbers?
I can give them, once I've got Adrian.
No, you give them to her now because I know what happens with this sort of thing. You then refuse to give it to them afterwards.
Right now.
Exactly. We're not new to this game. We support many families.
My thing. Just put it on the front for you.
Needs your QID number on it.
And he'll be well aware of what those are, and he knows they are required.
Okay, Vanessa, we need to.
I don't have hold of him. He has hold of me.
Okay, Adrian.
And I'm not going to forcibly remove my own child.
Adrian, we need to go, mate. There's no getting past this.
Well, there is, but you're choosing to ignore it.
But you've been taught through that, haven't you?
As what you are doing is illegal.
No, it's not.
They do not have a valid plan. Without a valid plan, they cannot have a Section 101 order.
We've got the order, mate. That's all.
No, that was when the plan
So
was
what
valid.
you've,
It's no
what
longer
you,
valid
what you've got
because
a,
the plan says he is to live with
I'm not
Elizabeth
going
Fair.
to argue with you.
you have a Section 101 order they've shown you that was based on a plan that was placed before the court that is now expired because of the change in material circumstances for Adrian, and therefore has to go back to the court. The court, the OT are well aware of this, and I would question the fact that the New Zealand police are well aware of it too, as they do so many of these uplifts unlawfully.
Nowhere here. We're not going to listen to them.
He's just going to keep saying he's not listening to you.
Oh, hey, Vanessa, that's fine. Vanessa, that's fine if he's not going to listen, okay, because this will be going into the court and he can explain to the judge why he didn't listen.
I don't know why he's threatening that. I don't care.
There's no threat there at all, officer. You know that there's such a thing as a tort of professional negligence. You are being negligent in your professional capacity right now.
We're not.
You can't just turn around and enforce stuff that you feel you want to enforce and ignore the rest. It's that simple. We have proven that in the courts.
I grab Adrian, okay? We need to get out of here.
You're going to forcibly remove him now, Brent.
We're not going to muck around.
If they're going to do that, then Vanessa, turn your camera around and record them doing it, so that way we can show the court what this officer, went ahead and did anyway, even though it was all explained to him. Then he can be brought in and questioned by subpoena.
Hi, Adrian.
Adrian, I'm just going to pick you up, okay? We can't wait here all night. That's our problem.
It's not a case. It's not a case of can't wait there. It's a case of don't want to. It's a case of want to traumatize the child. Oh, so we're actually dealing with a detective and not an actual police officer. Okay. Yeah, make sure you get their faces on camera, Vanessa. And they cannot take your phone away from you.
Hi.
We don't want to do this either, mate.
We don't want to do this, Adrian. You got a piece of paper, Vanessa? I'll write down our few IDs and names.
Just right.
Your screen's gone black there, Vanessa. You make sure you get all of their faces on camera. Right, so he's just breached Section 22 of New Zealand Bora. They are now dragging him, so they are actually breaching New Zealand Bora. If you can, Vanessa, follow them right out.
I love you,
A child being dragged from his mother. Who is that there?
That's the other officer.
Okay, make sure you capture their face as well. And if Jono is out there, make sure you capture them as well.
Can you hear him screaming, Brent?
Yes, we can, yes. Just go up by them so that you can get a good shot of it. You're not obstructing them. is that John over there? If it is, get a shot of him.
Yeah.
Get a shot of him. And whoever the other person is, we're going to need their faces for court. No use hiding. We know who you are, Jono. Just in case you don't get the all the QIDs, Vanessa, get the registration numbers of the cars. Because then that way you've got a list of who the vehicles were. PFC 949, PNZ 536. Because they would be assigned to their jobs by that. Using unreasonable force and breaching the New Zealand Bora.
That's the OK
Yeah, of
social.
course, John will. You might want to get that other car too. What was? Oh, okay, that was social worker.
Oh, there's only two.
Okay. Okay. Well, I'll contact Graham later on, and we'll work out what we're going to do. Okay, Vanessa?
Yeah.
Okay. So I'm sorry it's gone that way. And I'll give you a call later on, Vanessa.
Okay. Thank you.
Okay. Bye.
Thanks. Bye.